I do expect, as it probably will come to no surprise to you, for you all to get along.
There's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that.
In the Bryan Kohberger case, more discovery battles, and they looked at 67 electronic devices. What's in there?
Some new bombshells have just dropped in the Bryan Kohberger case. I'm Lainey Law.
And I'm attorney Andrew Myers.
And we have a lot to talk about today as far as some new revelations that you might not have been aware of before. What exactly is going on right now, Andrew?
Well, Ann Taylor has objected to the fact that the state of Idaho prosecutors have done a snow job, really, by disclosing a bunch of experts, but not backing it up in conformity with the rules. But in the motion that we are going to take a look at right now, there's some new information that I had not heard of, and I think I've been following the case relatively closely. What this is a motion to compel pursuant to the Idaho criminal rule regarding disclosure of experts. It's a motion to compel material and for sanctions.
Yeah, so I'll start off reading it. Comes now Bryan C. Kohberger, by and through his attorney of record, and hereby moves this honorable court for an order to compel complete expert disclosures from the state in this matter, and requests sanctions pursuant to ICR 16. The bulk of the state's expert disclosures fail to include opinions and reports. These inadequate disclosures greatly prejudice Mr. Kohberger, who is obligated to submit defense guilt phase expert disclosures by January 23rd of 2025. The sanctions considered must be the exclusion of the experts or, at bare minimum, in order compelling proper disclosure and extension of Mr. Kohberger's January 23rd, 2025 deadline. Mr. Kohberger is prejudiced because he does not know what expert evidence the state intends to elicit. He does not know what expert evidence he must confront.
So what's going on here is the fact that the state bears the burden of proof beyond a reasonable doubt in a criminal case like this. And so they go first. They have to disclose all of the expert testimony that they are going to present at trial. And then the defense is given time, reasonable time, to respond, to get their own experts to digest what it is that the state is going to bring up at the trial. And what the defense is saying here is, they didn't disclose everything, so how can we reasonably, under the Constitution, provide a fair trial? So, relevant facts. In this case, there are over 68 terabytes of discovery. But wait a minute, I thought it was 51 terabytes. Where'd that come from?
Oh, the number keeps getting bigger, and I think it's hard to kind of comprehend how much like a terabyte of information is. A terabyte is like almost 1,000 gigabytes, about 1,000 gigabytes. And if you think of like a movie, that's like 2 gigabytes, and that could be like a 4K movie. Could be, well, 4K might be adding a little bit more gigs, but that's a lot of footage just to tack on to the pre-existing number, if it is footage or whatever that information is. I hope it's footage because it's large enough. I can't imagine a terabyte of text or just data is crazy.
So you're saying that this would be the equivalent of, it's not necessarily, but it's the equivalent of something like 34 feature-length movies?
I'm honestly, it could even be more because because the thing is too, if they're film movies, or just even depending on the size of the footage itself, they could be so much significantly smaller. You could have theoretically hundreds, multiple hundreds. You could have more than 200, more than 300. Oh my goodness. You could probably have 300, 400 in just 1 terabyte.
So a lot of it is apparently video. They followed the car through that weather site. They followed the car through traffic cams. They followed Hyundais, not necessarily the Hyundai, but Hyundais. They followed them. They might have ring cam footage. Who knows what they have, but a lot of it's going to be paper too. And I remember from my pre-video editing days for this episode for this joint venture that we're on, when I was just doing paper in the computer, it took me forever even to get up to a gigabyte of stuff in my computer. Now that I do video stuff, I've always been an amateur photographer, but even doing photographs, you might take a couple of hundred photographs, and even that doesn't take up that much room. So that is a huge amount of information. Okay, so in this case, there are over 68 terabytes of discovery produced in a method that the defense has repeatedly referenced in pleadings and at various motion hearings as extremely disorganized. There have been 20 specific requests for discovery and 6 motions to compel filed by the defense. The court entered a redacted order governing further criminal proceedings and notice of trial setting back on October 9th of 2024, and has notified the parties that strict compliance with the court's order is expected. On December 18th, 2024, the state disclosed 25 experts. That's a lot of experts.
It's a lot of experts.
Of that, only 5 include actual expert reports. Notably, not a single DNA expert opinion or report was produced. Yeah, remember how there was that whole issue with the genetic genealogy, and they said, oh, we're not going to use it at trial. So to not, in this disclosure on December 28th, to not have a single DNA expert opinion according to this motion, I don't know, that's really something. Instead, the state's disclosures refer to Bates numbered pages and say that this is provided as an aid. So it's kind of a general kind of a thing. It doesn't really get into what the expert materials are, which I thought was kind of odd.
All right, so at least 3 digital forensic experts are disclosed with lists of 67 electronic devices or third-party databases examined. Not a single report of what the 3 experts will opine related to any specific device or data is disclosed. 67 electronic devices.
Wow, what is 67 electronic devices? I've never heard that before in this case. Have you? That's an awful lot of, and they wouldn't be limited to just phones, I guess, iPads, iPhones, computers. I don't know. What could be in 67 electronic devices?
It says third-party databases examined, makes me think almost like a TikTok history or something. Like if they were doing something during the time, they could. That database is an interesting word, a standout word to me, because we have electronic devices or third-party databases. So one, that's a lot of electronic devices. 2, what kind of databases are we talking about? And what kind of information is on this database? Is it going to have timestamps for things?
Well, yeah, remember that, way back, much earlier in this case, we looked at the subpoenas that went out. Subpoenas went out to TikTok and Facebook and AT&T and Google. So they subpoenaed all of that stuff. So, obviously there's something in there. Obviously they've produced it. But I don't know. That's just that number stands out to me. 67 electronic devices. What could those be? I mean, obviously cell phones, iPads. Only so many of them could have been in that one house. So now are we talking about the 4 victims, Dylan Mortensen, Bethany Funk? Who were the people that were standing around outside? Who were the neighbors? Who were the friends? What about, get out the dun, dun, dun. And I don't know anything about it, but Brent Kopaka. What about him? So, I mean, that's just an awful lot of electronic devices, it seems to me, for 5, 6 college kids, for including Ms. Couch. I mean, I don't know.
So, argument. This is a capital murder case, and nothing about it is clear cut. The expert issues are complex, involving many different facets of DNA, cellular data, cell tower coverage, and drive testing. car identification, crime scene and blood splatter analysis, fingerprint analysis, forensic pathology, and electronic device analysis of the suspect, victims, and alternative suspects, and social media accounts.
Remember, we did an episode, and I've always said it's only me. I've always said I don't believe this was done by one person. I just don't. And I know we get comments out. Can you say that? Or, you don't understand if they're sleeping or intoxicated. Somebody could go through. No, I don't buy any of that bunk. I've never believed that whoever did this, and Mr. Kohberger is only a suspect. We have to remember that. He is only a suspect. I've never believed that these crimes of November 13th, 2022 at 1122 King Road in Moscow, Idaho were done by one person. But now they are, in fact, talking about alternative suspects. So that's why I circled that in red, because that really stood out to me.
And I feel like, I don't know, I think it says a lot. I agree that stands out. Alternative suspects is a strong way to phrase it.
Yeah.
At issue is the state's supplemental response to requests for discovery regarding the expert testimony and its exhibits filed December 18th, 2024. The disclosure lists 25 experts and provides curricula vitae, 5 with expert opinion reports and others with reference to Bates numbered pages or items, but no opinion data or methodology when the state's discourse does not follow the rules.
Let me just stop you there. I hate to be rude, but you know how I always say the good stuff is always in the footnotes? Look at this footnote. Mr. Kohberger does not include here a motion to strike the death penalty for failure to properly disclose experts. Without proper disclosure, that motion is forthcoming. So Ann Taylor is at it again, trying to knock the death penalty out of this case. And I don't know if a court would necessarily go along with that, although in the Lori Vallow case, when the prosecution was tardy in their disclosure of information, the death penalty was in fact taken off the table in a death penalty case. So if you don't comply with expert disclosure rules, and I'm only a member of the bar in Massachusetts and New Hampshire, but it's a pretty universal concept that if you do not comply with expert disclosure requirements, there are sanctions. One of them could just be a mere penalty. One of them could merely be, not allowing that expert on the stand. One of them could be, moving up one of your, there's all kinds of sanctions, but that's what Ann Taylor is saying, that she's not saying it right here, that she's doing a motion to strike the death penalty, but
it's forthcoming.
Without proper disclosure, that motion is, not might be, not maybe, that motion is forthcoming. So, all right. So, I'm sorry I stopped you, but basically what this says is that what the state's disclosure does not do is follow the rule. And the expert rules, like I just said, I'm only a member of the bar in Massachusetts and New Hampshire, but it looks like the Idaho rule parrots the federal rules 702, 703, 705, which say what I just said, that there are very specific rules for disclosing an expert. You must disclose, what their opinion is going to be, what it is based on, what are the materials that the expert has published. Are they peer reviewed? What other cases has the expert testified in? So that's basically what we're skipping over here, and I'll pick it up with, they're citing the rules. As the court explained in Mogen, when an expert relies on some form of scientific or technical information, that must be disclosed, as opposed to other witnesses whose opinions may be of the less scientific variety. The discovery rules are designed to safeguard the truth-seeking functions of trials, promote fairness and candor, to facilitate fair and expedited pretrial fact-gathering, and to prevent surprise at trial. It basically all goes back to the Sixth Amendment requirement that the defendant get a fair trial. If the state violates a disclosure requirement under Idaho Criminal Rule 16b6, the trial court has considerable discretion to fashion an appropriate 16K remedy. That's what I was just talking about. If you don't comply with these discovery rules, now the judge has a list of things he can do.
So, I'll take over the conclusion here.
All right.
Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial setting order. The expert evidence disclosed by the state is woefully inadequate. This is a capital murder case, and its compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23rd, 2025. And nicely signed off.
Oh, yeah. Here we have the signatures of Ann Taylor, Jay Logston, and Alyssa Massoth, the three primary attorneys on the defense side. And I think, reading between the lines here, she's saying she needs more time. Either the prosecution needs to come up with this stuff fairly quickly, or she needs more time, because her deadline is January 23rd, which is coming up pretty quickly. It's coming up pretty quickly. We're just done with the holidays now, and people are kind of taking a stretch and going, okay, I got to get back into it. And this is a rude awakening. So I'm thinking that she doesn't want to come right out and ask Judge Hippler for an extension, because the last time she did that, she got slapped. But she's saying, look, if you don't give me more time, it prejudices Mr. Kohberger and violates his Sixth Amendment rights. That's my reading of this motion. But again, the things that really stand out to me are, first of all, that many experts. Oh my gosh. 60. Oh, wait a minute. I'm sorry. Yeah. 25 experts? 25 experts? Are they serious?
Oh my goodness. I don't know. I feel it's interesting. I wonder almost there's so much more information coming out with this. It's interesting to see that this is even being disclosed in the first place, because everything has been under wraps so tightly up until this point as well.
And then the other two things that really stand out to me in this motion were 67 electronic devices, or as you pointed out, third-party databases. How many people did they grab their cell phones or iPads, or how many people's TikToks did they look into, and what were Maddie and all the others saying to each other, the night that they were in the bar and they were going to the food truck, and in the days before. I mean, it's still a mystery. The motive in this case is still a mystery. And so will it be a dent motion, or will it be another thud? I mean, we don't know. So the fact there were 25 experts, the fact that they went through 67 electronic devices, and the final dun is that they're talking about alternative suspects. They're talking about alternative suspects. What does it say here? The expert issues are complex, involving many different facets of DNA, cellular data, cell tower coverage, and drive testing, car identification, crime scene and blood spatter analysis, fingerprint analysis, forensic pathology, electronic device analysis of the suspect, victims, and alternative suspects. Electronic device analysis of the suspect, victims, and alternative suspects. Here's a question for our commenters. Who, dear commenters, are the alternative suspects? That's A. And B, what would have been on their electronic devices?
It's a crazy thought to have. And the thing is, too, with electronic devices, we don't really think about it, but so many people also have location sharing and things like that on rather. And there's just like, I don't know, our phones are just little like boxes filled with every single detail about us. I hope that we can come to a pretty clear conclusion, and that both parties are going to be able to agree on what they actually have, because that's a lot of information, a lot of data, all those terabytes.
It's a lot of data in there. The funny little side story is I was probably one of the last people in the world to get a cell phone. I was probably one of the last people in the world to get a cell phone. I don't need that. I'm just curmudgeon that I am. And so for Valentine's Day, my wife, I was married at the time, my wife gave me a cell phone. Wasn't that nice of her to give me such a nice gift? One of the first phone calls I got was from her. Where are you? So
yeah.
It started out simple like that, but then as you just waved yours in front, now our entire lives are in these things. Somebody just texted me. You probably heard the little. Everything is in there. Our location data, our financial data. Oh my God, my bank account got hacked, and the bank is like, whatever. Our Facebooks are in there, and that has all of our. Are they really friends? But they have all of our friends, our TikToks, our emails,
Your health apps that track your steps.
Yes, my health app has given me little warnings. You're not walking as much as you had. You have fewer steps. You have but yeah, everything is in there.
If I go to look at my steps real quick, it will tell me, and this is an embarrassing amount of steps, maybe don't look, but it tells you how many steps you took at what time.
Yeah. Well, that's very relevant. Going over to the Karen Reed case, John O'Keefe's health app said that he was inside the house and he went up and down stairs, and the prosecution has done everything they can to look the other way on that. But that's what his health app said, that at that time he was inside a house going up and down stairs, and so. There's a lot of personal information. So, fortunately I have a pretty boring life. So if somebody wants to look into my phone, I just got a text from one of my coworkers here. Are you going to be around? Are you going to be in the office? That's the kind of boring stuff. But the point is, with that many electronic devices and third-party platforms, and they're talking about alternative suspects. This is going to get good.
I'm looking forward to seeing what comes out, if anything comes out, if we're going to get more information on what we're looking at. And I'm curious to see if there's going to be any delays or extensions going on. What do you think?
I don't think this judge is going to allow any extensions. I think he'll tell the prosecution, guys, give her what she needs, or we're not going to let your experts on the stand. That is the ultimate sanction for failure to properly disclose the type of detail that the expert rules require. You just can't have those experts. So, okay, commenters, let us know what you think about all of this, all the new revelations that are in this motion. Do you want to start with what our commenters are saying?
Yeah, so from Agape Love 992, confidential informants are revealed during a trial and not before.
Yeah, that's true. And we did an episode a couple of weeks ago about the confidential informants. Who are they? And our commenters had a lot to say. Okay. In this one, Pansy Face 00 says, what followers want most? That people are innocent till proven guilty by a fair trial, instead of creators painting a picture of their guilt to persuade people to believe they are guilty. I don't think we've done that.
We certainly try our best not to. I think that's the thing with all of our videos. They either say that we're dumb for thinking that they're innocent, or that we're dumb for thinking that he's guilty. Yeah. And we don't even say one way or another.
I know. We've been very clear about that. I respect, and I'm only speaking for myself, I respect the constitutional presumption of innocence until found guilty or found otherwise by a jury of one's peers. But my real question had been, I had wondered in one of our previous episodes, and you can answer this question now. Followers of this case, what do you wonder? Not what you want, but what do you wonder? What questions are unanswered over and above the ones that I've just raised? Okay, and the last comment for today is
Roberta. The relevance I see is that BK was enrolled in a PhD in criminal justice. It would be reasonable to assume that he would know about the incident with the man and a knife in Pullman the year before, as it was not solved. It is reasonable to assess that it would be used as a warning to the women and give the students a challenge to solve, since BK has been compared to other serial killers, it would be reasonable to assume that he would copycat the same crime as that criminal has not been caught.
Oh, I should have given the background because you were off for the holidays when we did an episode on apparently way back in October of 2021. There was an incident in Pullman, Washington, in which a woman reported that at 3:30 at night, she was in her bedroom and a character walked into her room in the middle of the night with a knife, and he sprung out of her closet. And then when she kicked him in the stomach, he went back in the closet and then he disappeared. She called the police. Long story short, there is some body cam footage of the police interview with her. And ultimately, the police did an investigation and the crime was never solved.
It's so scary. Oh,
it's very scary. It gives me goosebumps even just to relate it. And so we spoke about that in our episode when you were off for the holidays. Yoli and I spoke about that, and people just chastised us. Why are you even bringing that up? It's irrelevant. And it was Yoli's idea to do it, and I at first rejected it out of hand. And then I thought, wait a minute, no. Does this create reasonable doubt that there's an unsolved crime of a person breaking into a woman's house in the middle of the night with a knife? If a judge, and we went on and on about relevance and whether it's more probative or prejudicial, and whether something like that would be allowed in the trial. And the person in the previous crime was described as being much shorter than Mr. Kohberger, who was 6 feet tall. And so I had a hard time even bringing it up. But then, you know how our commenters are. No matter what we do, we're wrong. I mean, if we hadn't have brought it up, all the commenters would have said, so-and-so had it on their channel, you know, as though so-and-so is the ultimate authority. We're just a bunch of schmucks. So we did bring it up, and we got all kinds of, what are you bringing that up for? What are you bringing that? So this was a good comment that, you know, they did point out that there is potentially some relevance. I don't know which way I'd go on this. Yoli and I went back and forth, and we didn't come to a final conclusion, but she pointed out, and I guess I agree with her. It could, if brought in the right way, it could raise reasonable doubt, and that's all a defense attorney has to do.
Mm-hmm.
So
And
see what you missed.
You know, it's crazy, but that's scary. If that happened, that's horrifying. And I do think, you know, I think she has a fair point that bringing something like that up could raise reasonable doubt if people were already scared to begin with.
The other facts, now that I stepped into this rabbit hole, this happened in October of 2021, way before Mr. Kohberger was out there. So it's very unlikely that he was a suspect, but it's out there. The final comment we got, this is very sad. I just wanted to let you know, you probably have heard by now, but in case, I wanted to let you know that your favorite criminal YouTuber, because I have mentioned him, the one with the rap music, the son, the content genius responsible for the episodes, passed away tragically and suddenly on November 17th. I'm so devastated. It's heartbreaking. Losing a son never goes away. We lost ours tragically 20 years ago. Time has not healed the pain and grief. I think that's why his death has affected me so much. Losing a son, any child, is something that no parent should ever have to endure. And we're talking, of course, about CLR Bruce Rivers. He's a great content creator. He has an incredible amount of experience as a criminal defense attorney, and he's not only a really good person who really speaks with experience, but he knows how to make it entertaining. You know how we get comments that sometimes we laugh or joke? He's able to make it work for him, and I bet he doesn't get, he probably does get complaints. But anyhow, this person from Australia wanted to mention that, and so that's fine.
Yeah.
We always mention that this case is about the Idaho 4, Kaylee, Goncalves, Madison, Mogen, Xana, Kernodle, and Ethan Chapin. So I just always mention that at the end, because we do have to mention that and end on a little bit of a serious note. But I always put you on the spot. Why do I always do this? What are your closing thoughts?
Oh, my closing thoughts are that I appreciate everybody that watches to the end. Obviously, you have a great point where this is about the victims of the case. And, ultimately, like, we want things to be done fairly. I hope it gets done fairly in a timely manner because the world wants to know what's going to happen. And if he's found not guilty, then what's going to happen? Like, are you going to then tell me that the potential murderer has been running around this whole time? I think, large part of society needs him to be guilty so that way they can feel safer. But this case has already taken so long. It needs to conclude. There needs to be some type of finality to this. Or what? Or we need to look for the person who actually did it.
Well, I'm going to dovetail right into that. And my closing thought is, who are these alternative suspects that they talk about in this motion? Where are all these 67 electronic devices coming from, and whose are they? Are they devices from the alternative suspects, from the bartender, from Bethany, from Dylan? Who are they from? And what is with this 68 terabytes of discovery? The discovery goes up and up and up, and I don't know. Okay, please be kind, be respectful. Don't personalize it in the comments. Tell us why you think something, or tell us what you think about an action that someone has taken. Don't call names because it will just be a waste of time. We'll delete them. So be kind, be respectful, whether you are at the gas station or the time-honored grocery store.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.